Hello and welcome. My guest today is Kathy McArthur, the founder of the McArthur law firm. With over 40 years of experience, $450 million recovered for her clients, and 4 rare certifications, she has built a powerhouse trial firm that consistently out-earns the Billboard lawyers by actually going the distance. We are going to pull back the curtain on the fraud in legal advertising, the $2 million risk of financing major cases, and the mentorship model Kathy uses to make herself obsolete while her daughters carry the torch forward. Kathy, welcome to the Growth Switch.
Thanks, Alex. I'm happy to be here this morning.
Pleasure to have you. Could you tell us about your original decision to go into the law? Because I understand when you were first at university, that was not the first thing that you wanted to do.
Really came from a background where I grew up in a small motel. That was my family's business. And I was in a very small town in Wilson, North Carolina. And I didn't even know any lawyers. I knew a few doctors, but I had great grades and scores. So when I went to college at UNC, University of North Carolina, I had no idea what I wanted to do. And that continued in that vein the entire time I was in college, since I got to my junior year and had changed majors several times, from thinking I was supposed to be a doctor to thinking I was supposed to be an accountant to thinking I didn't know what I was supposed to be. And then finally, because a boyfriend at the time was taking the law school admission test, LSAT, I thought, well, maybe that's it. So I took it and I made an outstanding score on it. So that more or less convinced me this is where I need to be. So I applied to law school, not having any clue really what to do with myself other than needing to do something. I felt like that I was, whatever I was interested in, I would do well at. It had been a sort of an interesting thing. I was Phi Beta Kappa undergrad at UNC, which of course means I had made great grades. And so I had interviewed for jobs with, by the time I graduated, my degree was in business marketing, and I could get a job. One of the jobs, I was flown around to interview several different places, and the biggest job I was offered was to be the night manager at a Pringles potato chip plant in Greenville, North Carolina, which is Procter and Gamble. So it was a big company, big job, and I thought, my God, is this what it's come to after all this academic success? I'm going to be a night manager in a potato chip plant. So that convinced me I definitely wanted to go to grad school. And so I went to law school not knowing that I wanted to be there, or had no clue really. It was just one of these things where I floundered, didn't do as well as I expected myself to do in law school because I just had no clue why I was even there. Graduated. I took the bar in North Carolina. I was married at the time. My husband was a PhD in constitutional law and criminal justice. He got a job teaching in Milledgeville, Georgia. So I moved with him to Georgia, had to take the bar exam here as well. And so I was a member of the bar in North Carolina, became a member of the bar in Georgia, and got with a law firm in Macon, Georgia, that was a trial firm. I became the right arm of a serious trial lawyer whose practice was growing at the time. And I stayed with that firm for 28 years, and it was just a wonderful opportunity. Female trial attorneys were non existent at that time. And so I had a big opportunity working with a major successful trial attorney who was building his practice at that time. So that was from 1979, 80 until 2017, I think. Yeah. That I stayed with that firm. The firm morphed into different things, but ultimately it was Reynolds and McArthur. We did trials all over the United States. We had a jet, twin engine. I don't know whether it was a citation, but it was we jetted around and we did trials in California and Florida and New York City and Kentucky, and we had success. And eventually, and I was co-counsel on a lot of major trials and big verdicts that had to do with products liability and car wrecks. And eventually we came out of the dark in terms of agreeing. We had thought we did not want to do medical malpractice
Mhm.
because we depended on the doctors who treated our clients to give favorable testimony in the injury cases. So, but eventually we realized that there were so many meritorious medical malpractice cases that the doctors who were good doctors did not resent us. In fact, they appreciated the work we did on that, as it turned out.
Mhm.
At any rate, so we morphed into doing a fair amount of medical malpractice cases representing injured people. Uh, and I haven't said this, but everything I've ever done in the practice of law had to do with representing, or has to do with representing injured people that have been injured by the carelessness of other people, corporations, doctors, hospitals, truck drivers, drunk drivers, falling down at the Kroger, whatever it is that causes a significant or serious or catastrophic injury or death. I represent people against insurance companies, et cetera. So it is something that I just semi fell into with my first job and stayed with it and trained. I got the best training in the world in terms of being a trial attorney and knowing how to do this work. And it just so happened that I absolutely loved it. I'm a perfect example of the Malcolm Gladwell 10,000 hour story that I put my 10,000 hours in, and it's just a true something I couldn't have predicted, didn't know I wanted, but fell into, and it turned out that, to be exactly what I wanted to do with my life, which is to help people at the worst time of their lives and make it better.
In the earlier days before you got to the 10,000 mark, did you have any specific moments that you can remember where you questioned your choice, maybe because things got difficult and maybe you needed a mentor? Or were there any crossroads in the road where you had to make the decision to stick with your choice?
Well, there are ups and downs in every career, I suppose, and there's one specific trial that we ended up it had to do with the death of a 20-year-old girl who was riding as a passenger in a car with a friend, and they were coming back in the middle of the night from a concert they were returning to Macon, and the driver fell asleep and veered off the road, and there was a truck. When they don't have the trailer on, they're called bobtail, meaning just the tractor sitting there. He was sitting there in the dark, and of course, the driver had fallen asleep, and they rear-ended the bobtail tractor, and the girl was killed. We represented her family, and the issue was, of course, the driver was responsible. He was not a family member or anything, so we sued him, but there was only $25,000 in insurance coverage on that vehicle, and he didn't have anything personal, so that was not going to be realistic compensation. So we sued the trucking company as well because the tractor was sitting it there in the dark, and it did not have the required triangles behind it and to notify traffic on the road that he was there. So
Mhm.
we ended up having to go to trial on that case, and the big issue was whether we were going to be able to hold the truck company in. It turned out they'd left it there for 3 days and, like that, without proper marking and all. We went completely through the trial, and the jury stayed out and in fact, the judge kept them out. They just stayed at the courthouse, and eventually, after midnight, they came back with a verdict, and the judge read the verdict, and he found, the jury had found against the trucking company, which
Mhm.
was a major victory for us, and then obviously had found against the driver, and then, on the damages, they awarded $25,000 for life
Mhm.
to the parents, and it was like, "What?" It was
Yeah.
a crushing loss on damages, and we talked to a couple of the jurors afterwards, and it was that 2 things that the patient had sent her or not the patient, the parents had sent their daughter to a boarding school that
Mhm.
was for troubled kids, and they
Mhm.
they felt like that the parents had not pursued their obligation as parents properly
Mhm.
and that they didn't deserve money for the value of the life of their daughter. And also the fact that she was out she'd gone to this concert. It was after midnight. She's returning home, and the parents were asleep at the house. They were not waiting up. And so the jury can remember walking across the street from the courthouse, our building where our office was there. And I thought at the time, my gosh, if something that is so completely and totally unjust like this can happen,
Hmm.
I wasn't sure whether I really wanted to pursue this kind of work because it just hurt so much. But, it was a terrible thing for our clients, the parents,
Hmm.
and it was just a really hard moment. And it was within the first 3 or 4 years after I started this work. And, of course, that wasn't the only case we had, and we had other successes. And I came around again that it was not our fault that the jury reacted that way, but it was a big lesson in that you cannot control what a jury does. We can only present the case to the extent that it's presentable and do the best we can with what's there. But that was a crushing defeat. I've had other bad results, very few, thankfully, that have shaken me to my core because I tend to take it very personally. But nothing has ever uh, shaken me to the point where I said, I don't want to do this anymore because the rewarding moments are so many more than the ones that where you feel like you've just been totally rejected and you need to drive your car off a cliff. That rarely happens, and the good times far outweigh the bad.
Has that experience, because you went through that personally, and from our conversation before recording, it sounds like you're quite a resilient person, and we will talk about your many other achievements. But did this story had an impact on how you train your associates in your current firm, how you prepare them to take the emotional toll of those cases as well?
Yeah, I remember there was another case that I heard about first happening. It was a boating accident where a mother was out with two little boys. They were 8. She was pulling them on a float that's called a banana,
Mhm.
attached to a long ski rope, and she was pulling them on the banana, and they were going around and out. They said, "Take us around one more time." But she was not doing anything she shouldn't have done. So she said, "Okay, one more time, and then we'll go in." And so what happened was along came a 16-year-old driving a high-speed boat, and he was looking behind himself um, as he drove fast. And when he looked back, here was this boat pulling the boys, and he didn't take the right step. He should have cut the motor because boats stop pretty fast. But what he did was he decided, "I have to jump that rope." So he gunned it, and the motor caught the ski rope and pulled the boys into the motor of his boat, and one of them was killed then and there, and the second boy was badly injured. But it was something I heard about, and then, um, it was just so catastrophic and awful, the idea of any mother having to be there to see. It was the friend that was visiting with them, the guest, that was killed, and her own son had to be helicoptered out. She stayed with the dead body of the other boy and had her husband went with their son. It was such a horrific set of circumstances. Then they came in to be clients, the parents of the deceased, and the mother was in such horrible shape that if she hadn't had a baby girl, I feared that she might kill herself just from the emotional pain. And, I've gotten off into a tangent about the emotional effect of this work, but it it felt good to be able to do something to help the situation, which getting money for a child, that can only help so far. But in that particular case, voting laws were changed as a result of that case because the father went to the legislature repeatedly and we supported him and we asked for voting laws to be changed so that a 16-year-old couldn't be driving that type boat that fast and had to have specific training and all that. But another thing, so that's what's good about this work is it can change the law. The malpractice cases can change how medicine is practiced. And I could give some examples of changes that have happened as a result of cases that we've had that have been horrific situations, but it changed how medicine is practiced and helped other people not have to go through the same thing. But as far as training people, young lawyers, to help me in situations like this, just getting across to them that supporting these people in their worst time of their life and then making something positive to whatever extent you can come from it is a very rewarding thing to do. As far as the trials themselves, my practice is to grade the trial after the jury goes out to deliberate. I then grade the trial.
Hmm.
Did we do everything we could have done? Did we make mistakes that we could have done things better? Did we turn over every rock? Did we do everything we possibly could have done to win this case or to come out with the best result possible? I grade the trial then because the first case I told you about was a result from that jury that there was nothing we could have done. We were stunned by it, so that it drove home the fact that there's only so much you can do, and you cannot control what a jury ends up doing with the case. So that you need to grade your performance not based on what the jury does, but on knowing what should have been done, what could have been done, what happened in the trial where you either were embarrassed or humiliated because you didn't do as much as you could have done and there were holes in the case that you didn't anticipate, or was everything done? And assuming it was, then I go ahead and grade it at that point. Then after the jury comes back, you can celebrate, or you can say, "Oh yes, we were great. We did wonderful things because look at what the jury did." But that's not necessarily what indicates, because I suppose you could do poorly in presentation and still get a great verdict depending on the case, but that's
Hmm.
not indicative of the quality of work you've done. So that's how I try to train my young lawyers is we're not looking at what the jury did, we're looking at how we did and what happened in the case. Did we do the best that could possibly have been done for these clients? And if we did, then that's an A.
I think that's a very great approach of focusing on the process, not the outcome, because you have to control what you can control. And like you said, some of the facts and other considerations is nothing you can do. But if you do the best with what you had and you prepared well and you left no stone unturned, then you did your job. And especially training law firm, that's the approach you want your associates to take.
And, also training young associates to, when the case comes in the door, we don't just take what's there and say, okay, we're going to present that case. We go further because we're trained to look for things like to look for whether the person's lying about their driving record, to search all the counties and the surrounding area for tickets that they've gotten that that don't show up on their driving record because they were reduced to 15 miles an hour or less
Hmm.
over the speed limit. Those don't show up on the driving record, and then they lie about it, and they may have. We had a case where the person had like 17 prior major speeding tickets that they had only told us about 4 or 5. In fact, he'd had 2 in the 3 months, 2 in 5 days that were within 3 months of the terrible wreck that he rear-ended a wedding party with the best man and another groomsman and 3 bridesmaids in the car.
Hmm.
He rear-ended them going 60 miles an hour and killed the best man, head injured 2 of the bridesmaids, brain injuries and neck surgery and bad orthopedic injuries for the driver who was a groomsman. We represented everybody in that car, but we didn't just take it and say, "This is a bad rear end collision, and he did a lot of damage." We looked behind it to find out that he just completely lied about his record. We took depositions. It was against AstraZeneca Pharmaceuticals, which is a huge major corporation. It was on a Saturday, and he was coming back from playing golf, They said he wasn't on company business, which he wasn't. But the fact is they gave him this car to drive. It was a company car. He was a pharmaceutical sales rep. So we sued the company for negligent entrustment of the car, and then we went behind that and found out that he was a excellent sales rep. He was one of their biggest producers, so that they had just basically turned a blind eye on this terrible driving record, that the part of it that they did know about, and then they didn't follow their policies and procedures to take that car away from him, and or to assign a driver to drive the car with him in it if they had to have it. But, so we could have just said, this is a terrible wreck with a terrible set of circumstances. We could have settled it for, good money, without finding out all this total, bad stuff about the driver and absolute, intentional negligence on the part of the company and not following their policies and procedures. So we tried one of those cases and we got a $15 million verdict, which is not what they would have paid just in settlement if we hadn't dug up all of this. And brain injury cases settled for confidential amounts, but it was a lot.
Mhm.
And even the driver of our vehicle, who was not at fault at all, but his case with neck surgery and shoulder surgery settled for a lot. And it had to do with our not just taking the case and as a rear-end collision, but doing the work to go investigate it and figure out why it happened, what all the background was, and it ended up that's where the fire in the case was, and it was terrible what happened, but the real fire in the case was everything that preceded it that caused it to happen. So
Mm.
that's the kind of work we do that adds tremendous value to the case, where if you don't file suit and dig up all this stuff, they're not gonna tell you this guy had a terrible, driving record, and we let him drive the car anyway. I mean, the company denied that they had any responsibility at all because this happened on a Saturday, and yes, it was their car and their insurance would cover, but that the company itself was not responsible, which the jury completely disagreed with that. And they said punitive damages should be awarded. Anyway, that's the kind of thing that our firm does, that if you're looking for a quick settlement on a case like that, it could have been had, but for a tenth of what we ended up getting out of it.
It's one thing to practice law and be as thorough as you just described in this example, but it's quite another to actually run the business of a law firm and manage in the practice. What was the moment when you started your career and you worked with litigators at the time that made you decide to start your own firm and continue growing the practice that you have today?
Well, there were several things, and I tell people, when you get right down to it, it's always about money.
Mm,
In law or whatever area you're looking at, typically, when you come down to the very basic reason why something happened, if you follow the money trail, that typically ends up being why. But in the firm that I was with, I was a named partner, but the my senior partner, who I'm still great friends with today, and he's 85 now. He's still practicing. He's still coming in and still loves what he does. And so um, I guess it's 19 years ago now. I decided that I needed to leave. Carl called himself a benign dictator, and
mhm,
I was the only lawyer in the firm at that time who I had just pitched a fit 5 years earlier and said, I deserve a percentage. I deserve the profits. And, it's Reynolds and McArthur. And, I'm doing all the depositions, most of the mediations. A lot of business is coming in because of me and the work I've done. At that point, I'd been with him for 23 years.
mm,
But anyway, I had really grown, and he was unwilling in the final analysis. He had grown into allowing me to do all of these things, and I was basically in charge of a lot of the firm and the other lawyers and everything that happened, and he was not participating because he was interested in timberland and airplanes and hunting dogs and playing a lot of golf. because he didn't need to be there because I was there. And it's not a matter of being taken advantage of. It was a wonderful opportunity that I had to grow into knowing what it took to run the firm. But in the final analysis, I just had said, look, I'll continue to do this. I don't want to leave. This is my family, but just let me make the same amount of money you do. That's all I care for. Yeah, just I'll make the same amount you do. I'll continue to, do it all, and you can continue to play golf and fly here, there, and yonder. And he said two things: that he was not prepared to do that, and
Mhm.
secondarily, that he felt like the business was not coming in because of me primarily, and wasn't saying primarily, but
Mhm.
he still believed that mostly the business came in because of him. So, um, I was put in a position that I either had to say, "Oh," and, uh, and I decided no. So 19 years ago, I had a daughter who at that point was, I think Lindsay and Holly were 15 and 11 at the time.
Mhm.
And I had made enough money that I knew they would go to college even if I fell on my face, and that it was time for me to leave. And in the meantime, in the practice of law, I had started and was the only lawyer in our firm who, as a sideline, I was doing workers' compensation work with a paralegal, Elaine Register. She and I had built this practice from 0 uh, to a point that those clients didn't know any other lawyer in the firm. I knew that that wasn't necessarily the work I wanted to do, but I knew it would pay the bills because all the workers' comp would go with us. So I decided that that since he was going to be like that I needed to prove to myself that that was not the case, that I would not fall on my face, that cases did come into me. So in, I guess, 19 years ago, in 2007, I opened McArthur Law Firm with myself, my right arm, Sheila, who's still with me today. And she's been with me 37 years. Elaine Register just retired, um, like 3 months ago, I guess January. She had been with me 36 years. That was the workers' comp paralegal. And so it was the three of us to start, and I was right. Cases had come in to me. I continued to get cases to come into me. I've done in these 19 years, I've done over 50 trials to a verdict, which I guess I could add it up 3 a year times, 3 a year for doing major trials is a lot in a year. Most people don't do, yeah, sometimes they don't do 1 a year. But,
Mhm.
so anyway, 3 times 19, 57, probably 50 plus trials to a verdict. I mean, last year we did 5. So, I mean, it sort of averages out. But, I think my old firm hasn't done 10 trials to a verdict since I left, because they don't have anybody that likes to go to trial. And Carl's not gonna do what it takes to get cases prepped to go to trial. So basically, I was his, star right arm that liked to go to trial, to prep the cases to go to trial, and that's what I enjoyed doing. So that meant that when I opened my own firm, and then I have, let's see, 7 other lawyers at this point that are with me, plus support staff, and support staff for the support staff. And, we've grown into, several offices, and but we're not considered a large plaintiff firm. We're not Morgan& and Morgan or anything like that. We are considered a medium size. We're not a mom and pop or a sole practitioner at all, but we have trial teams to handle most size injury claims. So that, and as you mentioned earlier, I opened my Atlanta office when my oldest daughter, who was with King and Spalding at the time as an attorney, she wanted to join us. So we opened the Atlanta office, and I now have both my daughters, who are both lawyers now. So from age 15 to 11, Lindsay's turning 30 and is with us, and Holly's turning 32, and she's also with us, both of them as successful lawyers.
That's quite a bet you made all those years ago, and it definitely sounds like it's paying off. Do you think a lot of drive to go to trials, not to sell, is your personality? Because one of the things that we spoke earlier about, there are so many billboard lawyers that just want to have a client, settle it in the shortest way possible. Like you mentioned earlier, not looking at the all details of the cases, just taking it at the face value, try to go through the process as quickly as possible. Do you think it's your personality driving it? And how are you also preparing your firm and your daughters to take over in the future to continue that legacy that you started?
Those are two different questions, both of them big questions. But as far as what drives me to try a case versus being a settling lawyer is that's just how I was raised as a lawyer, that this is what you do. And in
Mhm.
my mind, if I think there's an argument can be made for quick settlements, getting money into people's hands quickly. That does have some benefit. But if you only get about a tenth of the money in their hands that they ought to get, it to me is just not the way to practice law. It's not how I was taught to practice law, and it is a detriment to the client. So it's more or less how I was taught to practice law. That this is what you do, and if a client wants a quick settlement, of course we can do that too. That's just not generally, it's just ingrained in me that you turn over every rock. You find out why things happened. You don't just take what happened. You find out why did it happen?
Mhm.
Why was that 16-year-old driving that boat? Why was he, why, basically what led to this? Why was that driver for AstraZeneca still in that car? Well, we even went to the point of proving that I think it was, oh gosh, it was a psychiatric drug that the patent was running out on, that they were getting ready to be faced with everybody I think it was the drug Seroquel that they had a patent on, and that was running out, and which meant that the generic of that drug was going to be everywhere, and they were going to not make huge amounts of money. So they needed this guy to be out there just pumping, selling Seroquel as much as possible, and they put profits over people. I've got a little plaque over there that says, "Settle less often, expect great things." Um, you know, sometimes you go behind the facts of a case and you don't find anything.
Mhm.
But a lot of times you go behind the case and you do find facts, and particularly in malpractice cases, there's a lot of cover up that you do find. Um, anyway, it's really just how I was trained. Is this is the right way to practice law? You don't sell out a client and not do the work. You have to find out why it happened. Then you can advise the client appropriately. Yes, this is a reasonable amount of money for what happened, or no, it's not because this is why it happened, and a jury will give a lot more money for the same thing. It was the same injury, regardless of why it happened.
Mhm.
But how a jury is going to value it is what's different, and that's based on the why of why it happened. And so I think that I don't know how to practice any other way. I don't know how to do just quick settlement law. And so that's how I've trained my young lawyers here to get to the bottom of it, and then, and to approach cases instantly with, you know, spoliation letters to keep people from destroying evidence, getting accident reconstructionists in to download the electronics on tractor trailer trucks to find out what they were doing, getting their cell phone records to find out whether they were talking on the cell phone, to develop the why,
Mhm.
is is just how I was trained now, and that's how I'm training all the lawyers here, including my daughters, as far as to take over for me. But as far as how we'll accomplish that, I think that's I have gradually, and I think you already mentioned that I'm working to become obsolete, which means that the lawyers in the firm, the 7 lawyers are working. Every case has my name on it, but some other lawyer is working on the case and doing that digging and turning over the rocks, and I'm doing the advising on it. I still, at the moment, carry my own caseload of mostly medical malpractice cases, a few major catastrophic injuries that are not malpractice. But, we're working toward my not having a caseload of my own and just being a consultant with the other lawyers as far as what to do next, the case plan. And then I'm available. You know, you can't try a lot of cases. So we have enough cases that if we tried 5 in a year, that's a lot. That what that means is most cases settle. But I'm lead counsel on any case that goes to trial at this point, and I'm working toward the other lawyers having enough trial experience. And most lawyers never go to trial in their entire career. So that's not this firm. I'm working for these young lawyers to have enough trial experience that we can then reverse roles and maybe I'm there, but they're lead counsel on the case. And I'm there just in case there are questions or I need to handle something. But so I'm sort of working myself out of being needed, but I'm still there if I'm wanted or if the client, I don't put another lawyer in if it works a detriment to the case at all. I mean, as far as working it up, yes, but as far as trying the case, if the
Mhm.
client hired me, I'm going to be there if it adds value to the case. If it doesn't, I won't. But so that's how I'm gradually working myself out is by giving them experience to where they don't need me.
You mentioned when in 2007 you started your firm, the cases followed you because you've built the reputation and they knew how to find you. Now you've trained your younger lawyers to have your support and they know what they're doing. They're able to see the cases through. Have you, from the perspective of getting those cases in the door, you mentioned it's still a lot of your reputation and your name on it. How have you planned for them to start generating their own cases and to continue growing the firm with their name on them?
That's something that doesn't happen right away unless a lawyer's very lucky. But as far as how cases come in, it was always true that the best cases came because of word of mouth and not because of advertising. We don't do TV commercials. I think we may have 2 billboards in strategic locations, but we're not billboard lawyers or TV lawyers. But word of mouth brings in the best cases, and I've always preached that if you do good work, great work, and try to do great work on the case, and if you treat people right, the clients, and fairly, then they will send cases in, and it will lead to your being successful, and the cases money will follow good work, treating people right, getting great results. That will bring in more cases, and all of those things lead to making money. So you can't have the first goal be making money. You have to have the first goal being doing great work, treating the clients right, and then having them go out and be your lieutenants
Hmm.
for other cases to come in. A lot has changed over the years as far as how cases come in, and we're being hurt by so many lawyers advertising themselves as trial lawyers when they're not trial lawyers. They might not even know the way to get to the courthouse, so that's how to try a case if they got there. But they've never tried a case, and but they're advertising themselves as trial lawyers and as having the same credentials that we actually do have. Our website is a way that we get cases, that we have testimonials from the clients. We have reviews from clients that basically I'm lifting up the lawyers in this firm to gain in reputation because of dealing with the clients themselves. Then they're getting the reviews that say, Lindsay Macon is a wonderful lawyer and I would always hire her, or Jessica Edmonds or Jordan Josie or any one of the lawyers. It's spreading their name, even though they're not, because we don't have enough trials, they're out getting great trial results without me yet. They will. But, it takes a while to get your name out there. And Our firm is, we're sponsoring different things, around town. We're partners with the Coliseum that puts on a lot of concerts. We work with law enforcement and provide them with events like turkey shoots and shooting expositions and different things to work with them to where they know us, and if there's an opportunity to direct the case to us, they will. And getting cases in the door is hard now because of all the TV lawyers, Billboard lawyers, and lawyers who are willing to do unethical things to get cases, which we're not unethical and we won't do that regardless. But it takes time, and I think a plaintiff's lawyer, it takes a good 10 years for a lawyer to have enough people behind them that they've represented who know them, who know the kind of work they did, for them to be involved in their church and their community and clubs, organizations, such that they're well known enough and the work they do is well known enough that people will send cases to them and support the practice. And so, you know, uh, Lindsay has been with us for 6 years. Jessica has been with me for 12 years. Caleb, I think, has been with me for 14 or 15 years. Jordan has been with me for, gosh, 7 or 8 years. I may be a little wrong on these. Quintisha and Ollie are both, have been with the firm for maybe 3 years, 4 years. So everybody is growing in that direction, to where they should be self-sufficient and not need me to be the rainmaker as much. The website helps. All of our results help. One thing that's helped tremendously lately has been, that last year I decided that I would take board certification exams in trucking law and in medical malpractice law, which you wonder, was I not board certified already? Well, I was board certified already in civil practice and in civil trial practice and had just not bothered to go into the specializations that had come about since years ago when I became board certified. But I decided that I would become board certified, that I would take the test. I mean, it's a huge thing where you have to produce your body of work. You have to have done a certain number of trials. You have to have references from other lawyers, from judges. The application process to do these things is huge. And then the trucking test was monstrously hard and long. It was an all-day test where they put you under surveillance to make sure you don't cheat. Yeah, I thought at age 70, if I'm gonna have to cheat on an exam, that would just be pretty sad. Anyway, so I successfully completed both, and so now I have 4 board certifications, and as it turns out, I'm the only lawyer in the country who has 4 board certifications, which means I guess I'm, obsessive compulsive or something's wrong with me. But that credential has, when you put it on the internet, and I'm a top 10 lawyer with super lawyers and top 5 in personal, yeah, all this other stuff, that when people say, "Who's the best this or that?" our names are coming up with that. So that's another way that business has come in. So I would encourage my young lawyers, once they're eligible to take the exams for board certification in different things, that most lawyers don't do that. A very, very tiny percentage of malpractice lawyers and trucking lawyers become board certified. I think there are only 10 in malpractice in the state of Georgia, um, that have bothered to do it. You know, it's not required like it is for doctors in most areas. But anyway, so that is another way of getting business in, is to basically have your results, then have your credentials be such that nobody can compete with it. And then you just have to get the word out, which has been that's the hardest thing, because I tell people all the time, if people knew our credentials and our results, they would never hire anybody else to represent them on a major injury case. But getting that information out there is a marketing nightmare, and the law firms that are huge advertisers, and they're just, we call them advertising lawyers. They're putting so much money, I mean, millions into marketing to warehouse cases, and it hurts people who don't do that, which we don't. but I wish that we could get a handle on lawyer advertising sufficiently to stop the fraud because that hurts lawyers in general, hurts our reputations, which our reputations lawyers have always gotten kind of what I think is a bum rap by people making lawyer jokes and calling us sharks and lawyers being seen as, somehow scummy, when we're not, but until you need it. But, I think it really hurt the reputations of lawyers, all this advertising, and it also is a fraud on people who are really badly hurt, where they get hurt by somebody who's been careless or hurt them through terrible circumstances, and then they get a bad lawyer because of the advertising, and that just compounds the losses. So, I wish we could do something about it, but as it is, we're just trying to get the word out that not all lawyers are the same, just like not all doctors are equally qualified.
Absolutely.
But you know what? With us, the fees are the same. That's the thing. Our fees same or less as these people who are unqualified to handle the case. So it's an interesting issue and something we really struggle with.
Yeah, I think that it is important to educate potential clients about your body of work. The fact, like you said, you don't have to get the certification. So when you do, that's an extra step that sets you apart. And the better educated the clients about the cases you've done, then it will be better for them, not only for their individual case, but like you said, you can change the law to avoid putting other people in risk in the future. So that's a great thing all around. Kathy, it's been absolutely wonderful having you on. Thank you for coming on and sharing insights. It's been a pleasure.
Yes, thank you so much for giving me the opportunity to talk about all this. I love the practice of law. I recommend it to everybody. Obviously, I recommended it to my daughters. Anybody who doesn't know what they want to do with their life, become a lawyer. You don't have to do what I do, but there are 100 different directions you can go with it, and it is a wonderful life, and no one can ever take it away from you, the level of respect that most people give you when you say you're a lawyer. But thank you so much for letting me talk with you today, Alex. It's been,
My
lots of
pleasure.
fun, and I appreciate it more than you know.
Thank you, Kathy.